All right, well, welcome everyone to the post-graduation immigration options workshop today. We are so glad that you chose to spend your afternoon with us here at UCF Global. My name is Christina Kahn and I'm the director of UCF Global, and I'm very happy to welcome you to today's workshop. So to share a little bit about our agenda, today we will be going over post-graduation immigration options. And at the end, we will have questions and answers. So we received many pre-submitted questions. So thank you to everyone who sent in questions in advance. So we'll be able to go through a lot of those questions that were submitted. In terms of logistics, this session is being recorded and will be posted to UCF Global's YouTube channel after the session today. So sometime hopefully by next week, you'll be able to find it there. We ask that because there are so many participants in today's workshop and because we have so much material to cover, that you remain muted throughout the workshop. If you do have questions along the way, please type your questions in the chat and our immigration advisors will be monitoring the chat. And if there's time after we've gotten through pre-submitted questions, we'll be able to address some of the questions from the chat box. So today's session really focuses on immigration options after graduation, beyond OPT and beyond academic training. So just very briefly, if you are looking for information about employment options for F1 and J1 students, I would ask that you please refer to UCF Global's website. We have a lot of information, both about on-campus employment as well as curricular practical training, optional practical training, STEM extensions, and academic training. So the focus of today's workshop is really not going to be these types of employment authorizations. We're going to focus more on what comes beyond those opportunities. We are joined today by two immigration attorneys and experts on the topic of employment in the United States, Attorney Aaron Blumberg and Attorney Anilka Nortalis. So to share a little bit and introduce our speakers, Aaron is a partner at Fragomen's Miami office. He advises a diverse client base, including investors, entrepreneurs, colleges and universities, and multinational companies on U.S. immigration law. He has deep experience advising on distinctive immigration requirements of colleges and universities. He has worked on behalf of professors and researchers to secure EB1 at outstanding professor researcher visas and national interest waivers. He also advises international students on their visa options upon graduation and represents and assists a growing number of small businesses, startups, investors, and entrepreneurs who are working to expand their business footprint in the United States. Anilka Nortalis is a senior associate at Fragomen's Miami office. She primarily represents colleges and universities, as well as multinational corporations in the IT industry. She has more than 10 years of experience in employment-based and family-based immigration law and has represented multinational companies in various industries, including telecommunications and construction, as well as smaller businesses, startups, and entrepreneurs. Prior to focusing her practice on employment-based immigration law, Anilka primarily practiced family immigration law, drafting immigration court briefs, motions, and Board of Immigration Appeal briefs. So we are very thankful to both of the attorneys for being here with us today to talk with us more about immigration options after graduation. And with that, I will go ahead and hand it over to Aaron and Anilka.
Great. Thank you, Christina. Let's see if we're working okay. All right, I think everyone can see our screen, hopefully. Perfect. All right, well, thank you again to Christina, Zach, and Marguerite. It is always a pleasure to be presenting and speaking with the students and scholars at UCF. If you have come to one of my presentations in the past, you will see most of the material is relatively the same, and there's a reason for that. As much as you hear in the news about all the different changes and proposals, for the most part, the structure of immigration has remained the same. over the last few years. There obviously are some deviations and some exceptions and little changes, but for the most part, our immigration system and structure has been the same for well over 10 years. And we'll talk a little bit towards the end about some potential changes we may see under the Biden administration. So here's a little overview of what we're going to be focusing on today. To begin, I always want to make sure everyone understands the concept of immigrant and immigrant visa versus non-immigrant and non-immigrant visa. And so most of the people in the audience watching today are on F and J visas, which are student and exchange visitor visas. These are what are considered non-immigrants and non-immigrant visas, as opposed to an immigrant visa. So an immigrant visa is for somebody that is coming to the United States permanently, and an immigrant visa is better known as a permanent resident or a green card holder. A non-immigrant is somebody who is coming to the United States temporarily. So by being a non-immigrant, they are not an immigrant, which means they are not coming to the United States permanently, they're coming temporarily, which is the case for anyone on an F or a J. Some of the government agencies involved in the immigration process, we'll focus on DHS, Department of Homeland Security. They're comprised of USCIS, ICE, and CBP. And so USCIS is the agency that processes and adjudicates all the applications that you file for various immigration benefits. Most notably, when you apply for OPT, when you apply for an H-1B, or when you apply for permanent residence, it's processed by USCIS. ICE is Immigration and Customs Enforcement, and this branch of DHS, their responsibility is to make sure that immigration laws are properly enforced. And so if you're in the United States and you are doing something that is not permissible, whether that is working without authorization, overstaying your visa, you may see ICE come look for you. CBP is the third and final organization I want to talk about that's part of DHS. Customs and Border Protection, they patrol all of the borders. So when you fly in or drive into the United States and you're inspected by an officer, that is a CBP officer. Department of Labor will come into play when we talk about H-1Bs and certain green card applications. Their role is to make sure that the employment of foreign nationals does not disrupt the wages or working conditions of American workers. And then finally, the Department of State oversees all of the embassies and consulates throughout the world where you go to apply for your visa to enter the country. Okay, the legal structure of immigration law. I think everyone now has clearly seen over the last couple of years that immigration law is not static. It is changing frequently, and it is also quite inconsistent. Immigration law comes from many different sources. There is not just one definitive book of immigration law that has everything. So it comes from various sources. It comes from regulations. It comes from Foreign Affairs Manual, from memorandum, from court cases. And so all those little pieces all go together to comprise what we know as U.S. immigration law. And what makes it, I think, frustrating for people like yourself going through the process is that you don't necessarily know what's going to happen in the future. You know, what the policies are today may not be the policies in the future. And we saw this last year with the travel bans that went into effect really with not much notice, or the policies that went back and forth on whether you could, you know, take classes online and remote, or if you had to be in person. And you saw how things changed, and it kept you on edge, and it made things a little anxious and frustrating, in my opinion. Unfortunately, that is part of immigration. We do see these things. These changes and the inconsistencies. So many of you probably have experienced things like this where perhaps you and a friend applied for OPT on the same day, and one got their OPT in 3 months and someone took 4 months, even though you may have applied at the same time. So we do see inconsistencies like that. It's not something you need to be concerned about. You just need to be aware of the fact that not everyone's case is going to be handled the same. Okay, let's take a look at some of the immigration documents. So the first one is the visa stamp. So some people call this the visa, some people call it the visa stamp, the visa sticker, whatever it may be. It's this document that we're looking at the screen. And what I want you to understand is that this is your travel permit. This document does not give you any legal status in the United States. This document does not let you work. This document does not let you go to school. This document merely allows you to enter the United States. This is what you present to the CBP officer at the border when you enter. But then once they admit you into the country, this document really plays no role. What's important once you're in the country is your I-20, or if you're a J1, your DS 2019, and for either of you, F or J, the I-94. So just remember, this is an international travel document, and it's not important, it's not needed unless you want or need to make a trip abroad. So if you're in the country and your visa and your passport has expired, it doesn't mean your status has expired. It just means that if you want to travel abroad and see your family, you're going to have to go back to the embassy, which is quite a process these days, get a new visa, and then re-enter. So once you're in the United States, which I assume is most of the people, although maybe because this is remote, there may be some people from abroad, but most of you, I would assume, are in the US, probably in Orlando, and so you all should have an I-94. If you don't have one, go to the website on the screen, pull up your I-94, check it, make sure it looks correct. If there's anything that looks off, anything at all, check with your F1 or J1 advisor so they can help you get it corrected. It is your responsibility to monitor your I-94, which you get every time you enter the country, and to take action if it's not correct. Even if the officer makes a mistake, which happens frequently, if you don't pick up on the mistake and get it corrected, you are the one that will suffer the consequences. So please make sure everyone that's on an F1, F2, J1, or J2, make sure that it says that status and that it says that the date the status expires, or the admit until date, should be D/S, which stands for duration of status. Maybe a few of you, very, very few these days, have an I-94 that looks like this. It's the same thing. It's just they used to do it handwritten, and now it's electronic. I-20 for people on an F1, and then the DS 2019 for people on a J1. And then the last document is an I-797 notice of action with a new I-94 on the bottom. And so this is the document that you would get if you have an employer that files to change your status from OPT to H-1B. It's also the same document you get if they change your status to O1 or to TN or to to really any visa status out there. But for most of you, the H-1B is going to be your most logical or likely next step after OPT or after academic training. So this is an approval notice for an H-1B. And what happens is immigration, what they do is when you get your status changed or extended within the United States, instead of going to the CBP website to get your new I-94, immigration will mail it to you. And so this one-page document, the top portion is the approval notice of the H-1B, and the bottom portion is a new I-94 that says that you're now an H-1B status as opposed to F or J, and it provides an actual expiration date just to the left of where the arrow is pointing, an expiration date, and that's when your status will end. Okay, so what happens throughout the course of your journey through the immigration system is that anytime you leave the country and re-enter, or anytime you extend or change your status from within the United States, you will receive a new I-94. If it's by traveling, you'll get it from the CBP website. If it's through an extension or a change of status, you'll get it in the mail from USCIS. Each time that you receive a new I-94, that is the I-94 that will dictate and demonstrate your legal status and the date your status expires. Okay, so every time you get a new one, that takes over, and that really basically voids all the previous I-94s. Okay, so let's move into non-immigrant visas. So non-immigrant visas, as I mentioned in the beginning, these are visas for people that are coming to the United States temporarily. And there's two in particular that are really important, and that's the H and the L. And these are work visas, and what makes them special is that they're the only two visas that allow for dual intent. Dual intent is the concept that you can be in the United States temporarily on a temporary work visa, like an H or an L, but you could also have the second or dual intent to file for permanent residence. So if you want to get permanent residence, a green card in the future, the best bet is for you to first get an H or an L, and from there go to a green card. Is it required? Absolutely not. Is it recommended? Yes, 100% recommended by me, recommended by the university. That will make your life a lot easier if you can first get an H or an L. And just as a heads up, in President Biden's immigration reform bill that he proposed, he does propose extending dual intent status to F1s as well. This has been proposed before in the past. I don't honestly know what the chances are that this part of the bill would pass, but just to throw it out there that it is something that's being discussed. So these are all the different non-immigrant or temporary visas that are out there. Some of these are work visas, some are for other purposes. And so I put in bold the work visas and really the work visas that are more common or applicable to UCF, F1, and J1 individuals. So when you look at this, you can see pretty quickly that there's not too many options. And if I went through and explained what each of these meant and what the requirements are, a lot of you would see that your only option after you finish school and you finish your OPT is going to be an H-1B. And so that's what we're going to talk about and focus on first. Okay, so why is it that for most of you, the H-1B is the only option? Well, first of all, it's not specific to any country or nationality. There's a number of visas where only people with certain passports or nationalities qualify. For the H-1B, you have the same chance whether you're from Canada or Australia or India or whatever country it is, okay? So that's the first thing. The second thing is it's not specific to any type of job in the sense that there's some visas like the TN where only certain occupations work, or the L1, only certain types of jobs work. With the H-1B, it's somewhat like that, but it's very open-ended. As long as it is a specialty occupation, the occupation will qualify. A specialty occupation is a job that is specialized and complex and requires a bachelor's degree or higher in a specific field of study. So again, it's open-ended. It doesn't matter if you're working in the fine arts or in business or in science or in education or engineering, as long as it is a professional position that requires at least a specialized bachelor's degree, it will qualify. Now, while that is relatively open-ended, that is also the same reason why that's probably the primary reason why H-1Bs get denied. So usually if an H-1B gets denied, it's because immigration does not believe that a bachelor's degree or higher in a specific field of study is truly absolutely required to perform that role. So that's kind of the crux of it. There are a few other requirements that we'll get to in a few minutes. But before we get to that, I want to talk just logistically about how you can actually get an H-1B, because it's gotten a little bit confusing. So Congress decided a number of years ago that they would limit the number of new H-1Bs issued each year to 85,000. 85,000 is a really, really low number because in the past few years, there's been well over 200,000 applications for H-1Bs, with, again, only 85,000 that are being issued. So what this means is that inevitably, every single year, there are more people that want an H-1B that just don't get it than people that are actually issued H-1Bs. Less than 50% of people that attempt to get an H-1B will actually get one. And it's because of this limit. Now, I'm going to talk in a minute about how it works to register and compete for one of these 85,000. But before I get to that, what I want to mention is that there are a number of employers that are exempt from this 85,000 limit. We call these cap exempt employers because they are exempt from the cap or the quota of 85,000. These employers are colleges and universities, and I don't have it up here, but it's a not-for-profit colleges and universities. So Trump University does not qualify. Organizations that are nonprofits that are affiliated with colleges and universities, and then nonprofit research and government research organizations. So two things to note about this. One, it doesn't matter what you do as long as the job requires a bachelor's or higher. So if UCF wants to hire you to be a financial analyst, you'd be cap exempt. They don't have to sponsor you to be a professor or a researcher or anything like that. It's really the same as any other employer, except they get to skip this quota and skip the lottery. The other important point about this is that you don't see on this list of cap exempt nonprofit companies, nonprofit entities. You see nonprofit research, you see nonprofit affiliated with colleges and universities, and you see nonprofit colleges and universities. But if it is a nonprofit that isn't engaged in research and isn't a government entity and isn't affiliated with a college or university, that employer would have to be subject to that 85,000 quota. Okay, so the H-1B registration lottery, oh, I think I have the dates off there. So first one, March 9th to, I believe it's March 25th. Your employer would register you in the H-1B lottery. So that is about to happen, okay? So what happens is if you have an employer, let's say you're working with them on OPT, they see your OPT is expiring this summer, they want to keep you longer, they would enter you in this lottery literally next week, okay? This lottery happens once a year. So if they don't get it in the next 2 weeks, they have to wait till March of 2022. On March 31st or April 1st or around then, the results of the lottery will be released. And then if you win the lottery, you have 90 days to file your full application with immigration. And note that last year, what happened, and this was, mostly due to the pandemic, what happened is they picked 85,000 in the lottery, but then a lot of companies said, wait a minute, our business isn't even operating. There's a pandemic here. How is this person going to even come to the country if they're not here? Or maybe they're here, but we're cutting jobs, we're cutting hours. And a lot of companies just didn't move forward with actually filing the cases. And so they held a second lottery in August this past year where they selected additional people that were able to file. Don't know if that will happen this year, but just keep that in mind. The odds of winning the lottery depend on how many people apply. So you can see the numbers up there. The more applications, the lower your chances of winning the lottery. Now, there is a slight advantage for anyone that holds a U.S. master's or PhD, a U.S. earned advanced degree. This advantage basically gets smaller and smaller every year because every year more and more people get US master's degrees and qualify for this. So it's not as advantageous as it was 5-10 years ago, but it still helps, and it's the only thing that can help. As of now, nothing else helps. Doesn't matter if you're sponsored by a top company, doesn't matter if they want to pay you $1 million a year, it's not going to give you any advantage. Next year, it might, because they're talking about changing it from a lottery to allocating visas based on your salary. I am not a proponent of this, but that is something that they're discussing. I think that will negatively impact international students. Startups will be hurt. Small companies will be hurt. And who will it benefit? Probably FANG companies, Facebook, Amazon, Netflix, Google, companies like that pay a lot of money. So we'll see. That's something that they're debating, and we'll see what happens. But for now, it's a random lottery. Okay, so let's say you win the lottery, your employer files, and the case gets approved. Great. You know, you did it. You got through the system. You're on an H-1B. You can be on an H-1B for up to 6 years total. There are exceptions where you can go beyond 6 years. Mostly, if you have a green card in process, you can go beyond 6 years. Now, let's say you are working for the company that sponsored you. You've worked for them for 2 years, and then you get a great offer and you want to go switch to a new job. The first thing to remember is you've already used up 2 years. There's a 6-year limit, so you only have 4 years remaining, okay? It's not 6 years per employer, it's 6 years total. So if you used up 2 years already, you have 4 remaining. So let's say you're going to try to change employers. I have 4 different scenarios up there. First one is cap subject to cap subject. So what this means is Google sponsors you for an H-1B, they win the lottery, the case gets approved, you work for them, and then 2 years later, or a week later, or 4 years later, whenever it is, you get this better offer from Facebook, and you transfer from Google to Facebook. No problem. It's actually relatively straightforward. Getting the first H-1B is the tricky one. Transferring it is not that bad. If you want to go cap subject to cap exempt, so from Google to UCF, no problem, very straightforward. Cap exempt to cap exempt. So let's say you never went through the lottery. You work at UCF and you want to move to University of Miami. Very straightforward, no problem. Again, you can only use whatever time you have remaining from that initial 6 years. Cap exempt to cap subject. This is the difficult one. So let's say you work at UCF on an H-1B. The fact that you work at UCF means you never entered and never won the H-1B lottery. If you want to change to a cap subject employer like Google, Google will have to register you in March. You'll have to win the lottery. They would file the H-1B, and then if it's approved, you'd be able to start working for them no earlier than October 1st. And by the way, as a side note, I didn't mention this before, but for anyone that's being sponsored by an employer for an H-1B that has to go through the lottery, so cap subject, the earliest your H-1B can take effect would be October 1st. And I'll get to that in a minute because it's going to be important depending on when your OPT expires. The last point up there is concurrent employment. So this is kind of the only trick or way to get around the lottery. Let's say you work for UCF and then Google doesn't want you to leave UCF to work for them exclusively, but they say, continue at UCF, but we want to hire you to work for us for 5 hours a week or 20 hours a week or whatever it may be, part-time. You could file, or actually Google could file, a concurrent H-1B where they would be able to bypass the lottery because your primary employment is with UCF, which is cap exempt. And so as long as you maintain that primary employment at UCF, you can maintain this secondary employment with Google without having to enter and win the lottery. Okay, so H-1B basics and FAQs. So first off, you cannot file an H-1B for yourself. Your employer must file it on your behalf, and they must establish that there is an employer-employee relationship. Once the H-1B is approved, you can only work for the employer that sponsored you, and you can only work in the position they sponsored you for. If there is a change, if they want to promote you, or if they want to move you from one office to another office, before they do that, they need to file an amendment. Okay, that's very, very, very important, especially because immigration, at least pre-COVID, although they do it a little bit now, they do random site visits where they will just show up at your door of your office and basically invite themselves in and just check to make sure that you're doing what you're supposed to be doing. An H-1B can be part-time or full-time. That will not impact your chances of winning the lottery if it's only part-time. If you lose your job, you have a grace period of up to 60 days. So just to clarify, J1's grace period, 30 days exactly. F1 grace period, 60 days exactly. H-1B grace period from 1 to 60 days, depending on when your I-94 expires. So whether you quit or whether you're terminated, your grace period will be a maximum of 60 days, but it cannot exceed the date your H-1B expires. So if you quit on May 1st and your H-1B expires May 15th, your grace period goes to May 15th. But if you quit on May 1st and your H-1B expires in November, you will have the full 60-day grace period. Grace period can be used to change employers, change status, or depart the country. Okay. Traveling, very similar to how you travel now. You have to go apply for a visa. There is an H-1B travel ban right now. We don't know how long that will continue, but not really recommended to be traveling right now if you can avoid it, but definitely check with if you're on an H, your immigration attorney, or if you're on an F or a J with your advisor. Spouse and children would get an H-4. H-4s are not eligible to work except for some really, really narrow exceptions. But in the Biden proposal, they do propose expanding eligibility. So all H-4s, all spouses and all children can work. Again, just a proposal. We'll see what happens. The fees, by law, the fees must be paid by the employer, both the attorney fees and the government fees. And I put up on the screen what the fees are. Okay, so the other requirement that I was referencing before that I wanted to come back to is the wage requirement. So in order to get an H-1B, the employer must demonstrate that they are paying you the higher of the prevailing wage or the actual wage. So the actual wage is what the company ordinarily pays to similarly situated employees. So if you're an entry-level electrical engineer and they have 5 other entry-level electrical engineers, you all should be getting paid the same amount, or if not, there needs to be a legal justification why it's different. You know, maybe all of you have a bachelor's in electrical engineering, but one person has a master's, or one person has a few years of experience, so they get paid more. So that's the actual wage. That usually is not a big issue. It's the prevailing wage that can be problematic because the prevailing wage is a salary that is determined by the Department of Labor. It's based on what you do, where you do that work, and whether you're entry-level, mid-level, or an advanced level employee. So we have had some issues with prevailing wage. We see issues more frequently for startups and small companies, but it really varies. You know, we randomly see that certain positions in certain parts of the country have really high wages, and sometimes it can't really even be explained. The one thing I will point out is that there potentially is a regulation coming out later this year. It's being reviewed now that would increase prevailing wages across the board. And this would be tough. Again, it's like a lot of things. It won't hurt Amazon or Facebook, but it'll really hurt small companies, startups, and possibly even universities. So it remains to be seen. as you can tell, there's a lot of things up in the air, a lot of proposals, a lot of potential changes. To be honest, most of these don't end up going through, or as you've seen in the last 4 years, they go through and then someone files a lawsuit and then it goes back to how it used to be. So we'll see what happens. Okay, let's talk about the cap gap extension. So I mentioned before that if your H-1B gets approved, it would take effect October 1st. So maybe some of you in the audience are thinking, how does this interplay with my OPT that is going to expire this summer, maybe in May or June? So what happens is there's this provision called the cap gap automatic extension. And the way it works is if your employer files for your H-1B before your OPT expires, your OPT gets automatically extended until September 30th. And then your H-1B takes effect October 1st. So easy example, you're on OPT right now, your OPT expires June of 2021. You file in March for the lottery, you win the lottery, and then in April, you file your H-1B, and it gets approved, and it says takes effect October 1. Well, because you filed the case, and by the way, it doesn't mean file it for the lottery, but winning the lottery and actually filing the case before your OPT expires, in this scenario, that person would get the benefit of this cap gap extension. Now, on the flip side, let's say that you graduated in December and your OPT just started maybe a couple weeks ago. Well, that's where it's a little bit trickier, because either you try to get an H-1B right now and your OPT would be shortened, or if you wait till next year, the danger you run into is that your OPT will most likely expire before you're even able to file the H-1B. And because you're filing the H-1B after the OPT, you're not going to be able to benefit from the cap gap extension, at least not for work authorization. If you file before your grace period ends, you can extend the grace period for several months, but for most people, that's just not a terribly helpful solution. But just keep this in mind. This is something that only helps OPT and F1 OPT students, so it would not apply for J1s on academic training. So here's the summary of your obstacles for an H-1B. It's first finding a job that's willing to sponsor you, that's willing to pay the H-1B fees and meet the prevailing wage, filed by the strict deadlines, win the lottery, and get the case approved. So that's what you're looking at to get an H-1B. So what happens if you can't get an H-1B? Well, I would say for a lot of people, if you only have a bachelor's degree, you probably want to consider maybe getting a master's. Maybe you want to try to get some work experience outside the US, or maybe you want to look at one of these other visa options that we'll briefly discuss. So the first one is the L1. The L1 is for an intra-company transferee. So let's say a big multinational corporation sponsors you for an H-1B and you don't win the lottery, but they really, really like you. And so they say, why don't you go work for our office, maybe in your home country, or maybe we have an office in Canada where it's a little easier to get a work visa. And you go work overseas for this company for at least 1 year as either an executive or a manager or someone who possesses specialized knowledge. That company can then bring you back to the United States through this intra-company transferee visa, the L1. Okay, so it's something that I think a lot of people should consider, especially if you can't win the H-1B lottery. I think it benefits you a lot to get some, experience abroad. And then, if you can come back to the US using this L1, it is a dual intent visa. So it is a good visa to have if you eventually want to get permanent residence. E1 and E2, these are treaty traders and treaty investors. This would be a visa option if you want to start your own business. It involves making an investment, either starting a business or working for a business that is owned by individuals of your same nationality, assuming that nationality qualifies for an E1 or an E2. So this is where it gets a little confusing. And I mentioned this in the beginning, H-1B doesn't matter where you're from. E1 and E2, it matters very much. Only certain countries qualify for the E1 and the E2. And notably, India, China, Brazil, and Russia do not qualify. Okay, so it's a good visa if you want to start a business, although it does require you to make a substantial financial investment into that enterprise, but not a great option considering a lot of people don't qualify. Up on your screen, this is the list of countries that qualify. Some countries you can do E1 and E2, some only E1, some only E2. If you have dual citizenship and multiple passports, you can pick whichever one works the best for you. Okay, so the O1 is a work visa for people of extraordinary ability. This is a very difficult work visa to get approved. It is for people that are the best and the best of their in their field on an international level. It really depends on your situation. For most people, it's going to make more sense to try for an H-1B, and maybe if you have a really strong case and you don't get the H, this could be a potential backup. This is the criteria. You need to meet at least 3 of these 8 criteria that's on the screen in order to get approved for the O1. The H-1B one is very similar to the H-1B, except it's only for people from Chile and Singapore. It does not have dual intent. And there is a quota, but we've never reached the quota, so I wouldn't worry too much about that. E3 is a work visa, also very similar to an H-1B, but it's only for Australian nationals. It does not have dual intent, and it has a quota, but we've never met that. We've never reached that quota of 10,000 a year. The TN is a work visa for Canadian and Mexican professionals. So this is only for Canadian and Mexican citizens. And you can only get a TN if you worked in one of these occupations that's on the screen. So it is quite limited. Okay, and that concludes the non-immigrant or temporary work visas. I want to hand things over to Anilka, who's going to talk to you for a few minutes about green card / permanent residence options.
Great. Thanks, Aaron. As Aaron has discussed the non-immigrant visas, I'm going to go on and focus on immigrant visas, even though he did mention a couple of things about them in the beginning. So basically, as Aaron mentioned, immigrant visas are coming to the US permanently as a green card holder. As many of you are aware, green card holders are also referred to as permanent residents or immigrants or legal permanent residents, and as we like to say, LPRs. So you might hear me say LPRs throughout the presentation. Green cards are numerically limited yearly based on the Department of State's visa bulletin and priority dates, which I will discuss in more detail further along in the presentation. After being a green card holder for 3 to 5 years, you can apply to become a US citizen. 3 years is applicable if you received your green card by marriage to a US citizen and you continue to be married to that US citizen. And then the 5 years is applicable to everyone else. So I want to go over some green card basics. And I know Aaron also mentioned that although it's strongly recommended that you do have an H-1B to file a green card, is not necessary. As he stated, it is a dual intent visa, so that temporary intent with other visas are not applicable. Also, being in the US for a certain number of years will not help or hurt your green card application. Some people might think they've been here for 10 years, this will help out my case. It doesn't work out that way. You can also obtain a green card even if you've never stepped foot in the US. For instance, if a family decides to sponsor you and you are abroad, that green card can be processed through consular processing. I also want to point out that you can have multiple green card applications pending at the same time in different categories. Again, you can have a family member sponsor you, and you can have an employment-based green card application as well. For employment-based sponsorships, you can be sponsored by an employer that you don't currently work for, as long as you have the intention to work for them once you receive that green card. So it's basically a offer for employment in the future. For green cards via family, employment, investment, or diversity lottery, these are all based on your country of birth, not country of citizenship. And finally, you can always include your spouse and unmarried children under 21 in your green card application, so they will be able to receive the green card along with you as well. Now, how to get a green card? There's generally 5 ways to get that green card. As I mentioned, it will be family sponsorship. 2 would be work or employment-based sponsorship, the diversity lottery, asylum, and the Cuban Adjustment Act. So I'll just quickly go ahead and touch upon the diversity lottery, which is a program that was created by Congress to encourage immigration from countries that are underrepresented in the US. So that means if you were born in certain countries that are overrepresented in the US, you may not be eligible. Here we have some of these countries that do not classify or cannot be part of the diversity lottery. So that includes, for instance, Canada, Brazil, Colombia, Dominican Republic, just to give you an idea. The way that you apply for the lottery is the application opens up from October to early November, and you can apply. It's on the Department of State's website, and they have allocated 50,000 green cards a year for the diversity lottery. So how are the winners chosen? The Department of State chooses the winners through random computer selection, and the results are published from May through September. So from those 50,000 green cards that are available, there's about 15 million applicants a year for the diversity lottery. So as you can imagine, it's very difficult to obtain a green card through the diversity lottery.
Hey, Anilka, I just wanted to add that in Biden's immigration proposal, he proposed increasing this from 50,000 to, I want to say, 80,000. But then at the same time, last year, there were a few proposals to move it from 50,000 to 0. And to use those green cards elsewhere. So there's a lot, there's always talk every year about changing this. So I recommend apply as soon as you can, as much as you can, if you qualify and if it's still around.
Yes, definitely. So yes, and along those lines, here we have a list of some of the countries with the most DV lottery winners throughout the years. For instance, Albania, 4,484, but out of those 4,884, only 2,630 people got the green card through this program. So it's definitely very difficult to obtain one through this program. So now we can go ahead and move on to the family-based sponsorship, in which family members can sponsor certain categories of relatives. So there are various categories of family relationships that range from spouses of a US citizen to siblings of a US citizen. The specific category and waiting times involved are listed each month on the Department of State's visa bulletin. However, the quickest process is for immediate relatives, and that's because there's no green card quota for immediate relatives. And these are spouses, minor children who are unmarried, and parents of US citizens. Then we get into the slower process in what we refer to as preference categories. So in this case, these are, there is a limit for green cards allocated every year. So these are for F1, unmarried sons and daughters of citizens. There's also the F2A and the F2B, which are for LPRs, spouses and children of LPRs, and unmarried sons and daughters of LPRs. And then we have the F3 category, married sons and daughters of citizens. And finally, there's the F4 category, which is siblings of United States citizens. So why is this important? Here we have the March 2021 visa bulletin. The reason why we look at these categories is because the Department of State monthly lets us know when there's a visa available for that particular category, as well as the area of chargeability. So once you begin the sponsorship process by filing Form I-130 with USCIS to establish the family relationship, USCIS will then issue you a priority date, which is basically the date of filing. You will then have to monitor this visa bulletin monthly to see if there's a visa available in your category. So for instance, if my US citizen brother filed a petition for me, then I'm in the F4 category. And let's say I was born in Nicaragua. So I will be looking for my corresponding chargeability area of all chargeability areas. If my priority date is before July 2006, then that means I have a visa available for me at this time. As you can imagine, the F4 category is the slowest one with more than 10 years waiting period. So now moving on to the employment-based categories, which, as you can already imagine, those are also broken up into categories. There's the EB1, priority workers, EB2, advanced degree professionals and aliens of exceptional ability, EB3, professional, skilled and unskilled workers, which require labor certification. Then we have EB4, special immigrants, and EB5, employment creation investors. And this is the one that requires a 1.8 million investment in the US or 900,000. So quickly, just to give you an idea of the difference between EB1, EB2, and EB3, the EB3 category or jobs require a bachelor's degree, and this always requires employer sponsorship. So you will need an employer to sponsor you for this type, for an EB3. For an EB2 job, this requires an advanced degree or the equivalent, meaning you can have a bachelor's degree plus 5 years of progressive experience. The only exception is a national interest waiver, which I will also explain later on. For the EB1 priority workers, the main difference between this and the other two categories is that there's no labor certification required. The EB1 has subcategories. Persons of extraordinary abilities, which is similar to the O1 non-immigrant category that Erin touched upon earlier. There's the outstanding professors and researchers, and the multinational executives and managers. All three require employer sponsorship except for the persons of extraordinary ability, which can self-petition. And so, as in the family sponsor and based categories, employment based also has their own visa bulletin that you must follow and look at to see if there's a visa available in your category as well as your chargeability area. So like I said, this is published by the Department of State monthly, and it's on their website. So for instance, if I was born in China and I have an EB-1 immigrant petition approved, and my priority date is before June 1st, 2017, that means that I finally have a visa available to me in my category. So now let's talk about the EB-1B outstanding professors and researchers, which in this category, you do need employer sponsorship to be able to file. You must demonstrate international recognition for your achievements in your field. And some of the other requirements is you must have 3 years of experience in teaching or research in your field, as well as the offered position has to be either tenure or tenure track, or a permanent research position at a institution of higher education. In order to demonstrate international recognition, the way that we do that for this category is to meet 2 of the 6 criteria that's listed here. For the EB-1 professor researcher, usually postdoc positions do not qualify because of their temporary nature of that position. For the EB-1 extraordinary ability, one has to have extraordinary abilities in either the sciences, arts, education, business, or athletic fields. In this category, the difference, like I said, is that you can self-petition, so there's no need for an employer to sponsor you. And the definition of extraordinary ability that you must establish is a level of expertise indicating the individual is one that has risen to the top of their field. This is definitely a higher standard than the exceptional ability or outstanding. So it's one of the tougher categories to meet. In order to be eligible, you must meet 3 of the 10 criteria listed here, which is basically the same as the 01 criteria that we went over previously. So this one is definitely a tough one. For the EB-2, and so now that we covered basically the different types of categories in the employment-based sponsorship, the next question is, well, what's the process? How do I get to that green card? So for the EB-2, EB-3 employment-based, there's a 3-step process. The first step is for the employer, since it's employer-sponsored, has to file what is called a labor certification on behalf of the foreign worker, or what we call a PERM. This PERM is filed with the Department of Labor, and it's basically a test of the job market in a specific geographic area, which confirms that there's no able or qualified workers for the offered position. For this, the first step is to file what is called a prevailing wage determination with the Department of Labor, in which the Department of Labor will review the duties and the minimum requirements of the position and then set a salary for that offer for that position. Then we would have to place mandatory job ads. And that's the way that we test the job market. If there's no qualified workers after those job ads, then the employer can go ahead and file that PERM with the Department of Labor on behalf of that foreign worker. So then let's say the employer, the recruitment is conducted, there's no qualified applicants for the position, and the employer files that PERM. The PERM gets certified or approved by the Department of Labor. Then we can move on to step 2, which is the filing of the immigrant petition or form I-140. Again, the employer files this on behalf of the foreign worker, basically confirming its sponsorship as well as its ability to pay the wages that were set by the Department of Labor. At this point, we're also trying to qualify the foreign worker for the position. So for instance, if the position, the offer position requires a bachelor's degree plus 3 years of experience, this is when we have to file with USCIS evidence that the foreign worker meets these minimum requirements. Let's say then the I-140 gets approved. Then we finally move on to the last step, which is the filing of the adjustment of status or the green card application, or if the person is not here in the United States, filing that green card or having that green card processed through consular processing at that person's country, wherever they may be overseas. At this point, this is filed by the foreign national and the family members. This is where the foreign worker files his personal documents, such as birth certificates, marriage certificates, and also financial documents to confirm that they will not be a public charge to the US, meaning that in the future, they will not need help from the US government. It is important to note that you can only file the adjustment of status or go through the consular processing only if your priority date for your category is current. If you can file within the United States, the government filing fees right now are $1,225. We've seen the fees change once in a while, so it's really good to keep up with those fee changes through the USCIS website. So after that, hopefully your green card application gets approved, and then you will receive your green card in the mail. Now, I know that you've heard me talk about the national interest waiver, so I just want to touch upon that quickly. The EB-2 national interest, or what we call NIW, is a request that the perm requirement of an EB-2 is waived in the interest of the US. It's granted to those with exceptional ability and whose employment would greatly benefit the US. So the 3 criteria that must be met is a bit different than the ones that we have seen previously with the O1 and the extraordinary ability. Here, the foreign nationals proposed endeavor has to meet both the substantial merit and national importance. The foreign national is well positioned to advance the proposed endeavor. And on balance, it would be beneficial to the United States to waive the job offer or that perm, which is a requirement of the EB-2 category. This is a good category for STEM PhDs, as it's, again, self-petition, so you don't need an employer sponsor, and you will be filing that perm along with your I-140. So there's no need to obtain a prevailing wage determination from the Department of Labor, and there's no need to do any job ads. So basically, instead of filing that perm with the Department of Labor, you'll be filing it directly with USCIS. So there you have it, an overview of the immigrant visas available through the immigration system and the different ways that you can obtain a green card through either family sponsorship or employment, as well as diversity, if that's still around. Now Erin will go ahead and discuss some general immigration advice moving forward, as well as some changes proposed by Biden recently.
Great, thank you, Anilka. All right, so let's just wrap up with a few last items. So first thing, Make sure you keep copies of everything, of all your documents. At this point in 2021, there's really not an excuse to not have copies of everything. So scan it, save it in the cloud. And I'm talking about things, not just I-20s and EAD cards, but like employment verification letters from places you worked on OPT and CPT, airplane confirmations. A lot of times you may have to go back years later and prove times that you left and came into the country. So just be organized, hold on to everything, not too difficult these days. Second point of advice is that if you're not sure, ask somebody reputable. And by reputable, I mean myself, Zach, Christina, Marguerite, Anilka, your F1 advisor, your J advisor, but not your best friend and not Alexa or Siri or any of those people, although they are getting smarter every day. So I may change this advice in the future. Next is, as an F or J student, really the worst thing you could possibly do is work without authorization. It's really, really strict. And so if your advisor says you can only work 20 hours per week on campus, that means that 20 hours and 5 minutes means you're in violation. So just don't test it. Don't think that you won't get caught, because you might. And if you do, the consequences are severe for unauthorized employment. The last thing, and related to that, is that the actions you take today may not have an impact tomorrow, but they may have an impact months, years, whatever down the road. So think about that. I think this relates not just to immigration. This could relate to things you put on social media or whatever it is. You're a student now, you're in school. Remember, at some point down the road, you're going to want a career, a family, and you don't want to be haunted by that time when you were on an F1 and you did a job on OPT that had nothing to do with your major. So think about those things. They may not catch you when you do it, but they may catch you years later. And what we're even seeing now is immigration, when people apply for citizenship 5 years after getting their green card, where officers are going back and saying, wait a minute, something's fishy about your green card application. And we've seen people that applied for citizenship that are permanent residents that get put into deportation proceedings. Very severe example, extreme example, but just again, make sure you do what you're supposed to do and follow the rules. When you apply for a job, these are the questions you're going to see. I wish I had better advice for how to answer these. These are really difficult questions because for a lot of you, the employer will only give you the option for yes or no. And very often the actual answer is maybe, or I don't know, or let me explain to you my very unique situation because I'm here on OPT and I don't know what the future holds. So that's, again, well, for this, if you have questions, feel free to ask and I'm happy to explain more. That is it. So thank you everyone for joining. And by the way, you are all the very first people hot off the press to be invited to our weekly Clubhouse immigration conversation, which is going to be starting next Friday at 1 o'clock. There's the link. I will be sending out an invitation to Christina that she can pass on to everyone. But what we're going to try is a few of the attorneys here every Friday from 1 to 2. We're just going to discuss hot topics in immigration, what happened that week. We will take questions. We encourage F and J advisors to join as well if you'd like, and of course, all the students. So with that being said, we will move on to questions. Let me actually leave this up here. Oh no. How do I go back? Okay, well, never mind. Christina, I'll let you get started with the questions. If you know how to put my our contact info back on the screen in an easy way. Okay, so Christina, do you want me to, are you going to read the questions to me? Or?
Yes, I'll go ahead and read the questions to you, and then I'll put your contact information back up after the pre-submitted questions. So the questions we're going to go through now were questions that you all have submitted in advance. So we'll get to those ones first, and if there's still time, we'll be able to address some of the questions in the chat. So here we go. First question. Is President Biden looking to make any immigration law changes that could help us stay in the U.S. post-graduation?
This is a perfect question because I thought I had a slide on this and I didn't. So this is perfect. So yeah, President Biden's looking to make a lot of changes. First, let me just preface this by saying these are all proposals. It's very possible that in 4 years, not a single one will become law, okay? But let me give you some of the ones that I think will impact you. First, I don't know if there's anyone here that is on DACA, but there are proposals for individuals that are here on DACA to be able to gain legal status and permanent residence. And that is something that actually is gaining bipartisan support. And I would not be surprised if that passes in the next couple of years. In terms of F1s, I mentioned before that there's a proposal to allow F1s to have dual intent, which will make life so much easier. When you're at the embassy and they ask you what your plans are after school, you can say, I'm going to stay in America and never come back, and you will not have a problem. Don't say that yet. Let's see if this passes, but that would be great. It would make it a lot easier for all of you to stay and get green cards. Another proposal is to eliminate the per country quotas that are for the green card system. So right now, the green card system, as you saw in that visa bulletin, it's based on your country of birth. And so if you were born in India right now and apply for a green card under EB2, the estimate is that it will take over 50 years to get your green card. But if you were born next door in Bangladesh or Sri Lanka or Pakistan, it'll take a few years, maybe 1, maybe 2, maybe 3. And so they're part of the Biden immigration bill would be to eliminate the per country quotas. So it doesn't matter where you're from. All that matters is what you do, how good you are at it, what your degree is, you know, whether you're EB1, EB2, or EB3. Other changes would be, let's see, there's a lot of other things that impact a variety of different classifications. I think those are probably the main ones for you. I guess on the H-1B side, there are part of his bill is to allocate H-1Bs based on salary. That one I don't really like because what will happen is the people with the highest salaries will have the best chance of getting an H-1B. But in my opinion, salary isn't everything. It doesn't dictate who's the most important to the country. You know, because if someone picked a field where it's not highly paid, or if they're entry level, or if they're working for a startup, they could suffer from that. So that's a proposal I'm not a big fan of, but that is out there. I think those are the main things that I think would impact you all, but if there's something specific in his bill, please go ahead and you can ask after these pre-submitted questions.
All right, moving to the next question. What steps can an international undergrad be taking towards getting a green card while in college?
Well, most of you probably won't qualify while you're in college, but what you can do is really what you're already trying to do. It's really working towards your career goals and educational goals will go hand in hand with working towards your green card. Because for most of you, you're going to need at least a bachelor's, preferably an advanced degree. You're going to need to do well in school so you get a good job at a company or some employer that's going to sponsor you. So really, I would say focus on doing well in school, making connections, networking. Networking is so important for getting a job. Gain experience, utilize OPT, utilize CPT, utilize on-campus employment. In my opinion, I think gaining experience in the summer is more important than, you know, finishing up and taking extra classes to graduate sooner. I think studying abroad and getting experience in other countries also will help. But again, this is advice that will help you in your career, but at the same time, it should help you with green card as well.
All right, next question. As a hospitality major, I heard getting an H-1B visa is a bit harder for us. What would you recommend for hospitality students?
It is a lot harder. And you know what, it's mostly harder in the more traditional hospitality fields that we think of, like working in a hotel or a cruise line. Nowadays, there's so many new innovative, tech-related hospitality jobs that maybe is a little bit better, but going with like traditional hospitality jobs, like working at a hotel, the problem is that a lot of in the hospitality industry, often what happens is, even with a hospitality degree, you kind of start off often going on rotation, where you kind of work front desk and you work, rooms, and you do, F&B, and you kind of do a little bit of everything to kind of gain experience. But it's more kind of lower level jobs that they often start you out with, because the feeling is you need to understand how it's done, because eventually you're going to probably be managing, a department. For H-1B, you really need to be like a manager. You need to be in a higher level role in order to qualify. Front desk agent's not going to qualify, but front desk manager may qualify. So think about it. It needs to be complex and specialized. So the higher level the position, and the more specialized it is, the better the chance will be for an H-1B.
All right. Are there any jobs or ways to avoid the H-1B lottery? And can you possibly go from OPT directly to permanent resident?
So you can avoid the lottery by working for a cap-exempt organization like UCF, and then go straight from OPT to permanent resident. You can. Just keep in mind a few things. It's a lot easier to do if you're eligible for the STEM extension, because then you have 3 years instead of 1. And then regardless of whether you have the STEM extension, it's really difficult for people from China, and especially people from India, because no matter what, the green card process takes longer, and very often will take much longer than the amount of time you have on OPT.
All right, moving on to the next question. If you win the diversity lottery, do you automatically get the visa?
No, and in fact, this is always heartbreaking to tell clients, but usually about 100,000 people win the lottery, and only about half actually get green cards. And they do this to make sure that they meet the quota. They don't want to announce 50,000 winners and then find out that 5,000 have criminal records, 5,000 say, oh, wait, I won, I'm not really interested. And then you only end up giving out 40,000 green cards. So extra people win because they know that after you win, there will be people that they find out don't qualify. You have to have graduated from high school or have 2 years of work experience, and a lot of people don't have that, or a lot of people have criminal records, or I've had clients that have won the lottery, but at the same time we filed for their employer-sponsored green card, and they get the green card, and so they just forget about the lottery. So that's how it works.
All right, we have several more. If I don't have an immediate job offer after graduation, what are my options? Am I able to stay here looking for a job for a specific period of time?
Yeah, so that's fine. I feel like a lot of students don't have a job offer after graduation, and that's fine, because to be honest, especially this year, you may not have your OPT already approved right after graduation. So this is what happens. Before you graduate, ideally you apply for OPT. While it's pending, you look for jobs. Once it's approved and you have the card, then you start working. So most people look for jobs during the 3 to 4 months while the OPT is pending.
All right. What options exist for a spouse to be employed?
It's difficult. And one of Biden's proposals is to allow all spouses of H-1Bs to be able to work unrestricted. Depends on the visa. So spouses of an L1 can work, spouses of a J1 can work, spouses of an E1, E2, and E3 can work. And then certain spouses of H-1Bs in limited situations. Anilka, any other categories I'm forgetting?
No, I think you covered them all.
Okay, yeah, so that's how it works. Of course, if you get sponsored for a green card, your spouse would get a green card with you and be able to work.
All right. Can I apply for OPT without a job offer?
Yes.
And I would just add that we have a lot of information about OPT in the OPT web course. I know Zach put a link in the chat, so please check that out if you haven't already. When should I apply for OPT?
I would recommend 80 to 90 days before you graduate, to be honest. You can apply as early as 90 days before you graduate and as late as 60 days after you graduate. I think it's really foolish to apply after you graduate at any time.
Awesome. Will the USCIS delays impact my OPT application?
Maybe you want to take that from what you're seeing on a day-to-day basis, but I mean, the quick answer is yes, but I don't know, Christina, if you want to talk more about that.
Yeah, sure. I mean, USCIS announced some flexibilities for students who are currently in the process of filing for OPT or recently filed for OPT. So because they've been very delayed in issuing receipts, and that also has cut into some students getting their full year of OPT. So there's some flexibilities there. If that applies to your situation, or if you have specific questions about that, please connect with your UCF Global Immigration Advisor and we'll look at your specific case. But in general, yes, the delays are frustrating for students because it's taking so much longer than usual. Moving on to the next question. For PhD students looking to start an academic position in early August 2021, would you recommend trying to get the hiring institution to apply for an H-1B visa with premium processing, or to get OPT and then get their hiring institution to sponsor them for an H-1B?
Both. I mean, I would go with the OPT for sure, and then talk to them about an H-1B. You know, it depends when you apply for OPT, because again, we are seeing delays. So if you graduate in May and apply in June, which you can, and you want to start in August, then you're going to need an H-1B. But if you're applying early enough, the OPT is probably the way to go, and then you can transition that into an H. But talk to your employer to, you know, sort that out.
All right, and there's a follow-up question to that. Based on your experience, what is the proportion of colleges and universities that hire international PhDs for academic positions through OPT first and then H-1B compared to H-1B directly at the start of employment?
There's no I mean, it's just a case-by-case determination. You know, again, it could be because someone was delinquent in filing their OPT and they have no choice but to do an H-1B. It could be someone that goes with the H-1B instead of the OPT because there's travel concerns, although nowadays it may be easier on OPT than H-1B. So every case is unique. There's no right or wrong way. It's just what makes sense for you.
All right, that is the end of our pre-submitted questions. So I want to ask Zach. Zach, our Assistant Director of UCF Global, has been monitoring and responding in the chat. Zach, are there any questions that haven't been addressed yet?
Thank you, Christina. Yeah, just a few quick ones that I'll just read off now. Aaron, the first one is, can you apply for the diversity lottery while in F1 status?
Yes, yeah, good question, Zach. Yeah, you can apply for it. What I recommend to people is if you win the lottery, I think you should consult with an immigration attorney about your options at that point. But don't worry about applying for it. You can enter the lottery. It's if and only if you win the lottery that, you know, at that point, it's a good idea to meet with an attorney and kind of plot out how to go about and get the green card now that you've won the lottery and how it will impact your F1 or J1 status.
Thank you, Aaron. The next question and the last question that I wasn't able to address in the chat is, what is prevailing wage? And do students need to exceed that wage or simply match that wage? So I think maybe just more clarification on the prevailing wage, how it's determined and what the metrics are. Like, does it have to be exceeded? Does it have to be met?
Yeah, so the prevailing wage is essentially the minimum wage for H-1Bs and for certain green card applications. It's set by the Department of Labor, and you have to either meet or exceed that wage?
Thank you. And those are really the questions that weren't addressed in the chat. So that's it from my side.
Wonderful. Well, I noticed that there were some questions that were pre-submitted related to OPT and also a lot of questions about OPT in the chat. So I would again encourage everyone to review our UCF Global OPT web course. It takes you through everything you need to know about OPT, as well as step-by-step through the application process. But of course, if you have specific questions after you've reviewed that, please reach out to us. We're here to help you. Feel free to give us a call or email us at ucfglobal@ucf.edu. I want to sincerely thank Aaron Blumberg and Anilka Nortelis for joining us, for giving their time to help us understand a little bit more about H-1B, permanent residency, and all of these other options that exist after graduation. So thank you everyone for attending. Again, this session will be posted to YouTube soon. So if you needed to go back to refer to it, it will be on the UCF Global's YouTube channel. And I hope everyone has a wonderful weekend. Stay safe and go Knights, charge on. Thank you, everybody.
Thanks, everyone.
Thank you, everyone. Have a great weekend.